Hello, I'm Professor Darryl Jackson, and this particular module or lecture will deal with the U.S. personnel laws or labor laws. Human resource and personnel departments throughout the nation must operate within a number of federal and state laws and/or regulations. Every federal civil rights and state employment law is designed to protect or remedy specified individual rights from employer-related infractions. In other words, these are your protections on the job. In the slides that follow, we're going to take a cursory look at what some of these laws are and the cornerstones of personnel law. In other words, I've tried to extract some of the landmark statutes and/or decisions with regard to personnel or labor law. Let's start with the early civil rights provisions. The Civil Rights Act of 1866 bars racial discrimination in making and enforcement of contracts. And this is going way back to the 1800s. Applies to both public and private employers. Simultaneously or jointly also, the Civil Rights Act of 1871, still in the 1800s, bars individuals from violating federal rights of another. It applies to persons acting under the color of state law. Now, what does that mean? This was particularly important in the area of civil rights when someone is taken into custody. You hear about all of the jailhouse shenanigans and this and that. Anybody who has some type of state authority, that particular thing. It was enhanced later on, but for the purpose of this particular act, it had to do with law enforcement and other individuals who were working in their official capacities under the what we call the color of state law or federal law. It was a protection that if they're acting in their capacity, they could not violate your civil rights, which are a host of civil rights, particularly those under the Fourth Amendment. The Fair Labor Standards Act of 1938, or FLSA, as amended, determines guidelines for minimum wage, overtime pay, equal pay, record keeping, exempt and non-exempt status, and child labor standards. It is a federal law enacted by the United States Congress in 1938. This law is enforced by the Department of Labor, the U.S. Department of Labor. The Equal Pay Act, going further, bars gender-based wage bias, applies to wages paid to employees who are engaged in commerce, engaged in the production of goods in commerce, or employed in an enterprise engaged in commerce. And that is FLSA. Age discrimination. There's an act for that. Age discrimination in the Employment Act bars discrimination against persons aged 40 or older. So this is getting toward what some people would consider elderly. There's a great deal of discrimination, particularly in this particular area when you have a bunch of baby boomers who are retiring from one particular position. A lot of people retire and figure that they need to go back to work because of economic circumstance or what have you. How do they reintegrate into the workforce? This particular act is still alive today, even though it was enacted many, many years ago, and applies to individuals who are over 40. It also applies to corporations that employ more than 20 individuals, employment agencies, and labor organizations. Disabilities. Americans with Disabilities Act of 1990. This is probably one of the newer regulations when it comes to personnel law. This act prohibits discrimination against individuals with disabilities and requires public services and accommodations to be usable and accessible by individuals. This is why there was a big push, particularly in the area of handicap services, to provide ramps and accessibility to buildings where before there was no accessibility for individuals who had some type of disability, physical disability and or handicap. Covers employees with 15 or more employees, employment agencies, labor organizations, joint labor management communities, the states, and the U.S. territories. Very controversial, the Family Leave Act, the Family and Medical Leave Act, or FMLA of 1993, is perhaps the latest of all the personnel laws that have been landmark in nature. It requires employers with 50 or more workers to provide unpaid, the critical word there is unpaid, but job protective leave up to 12 weeks per year to care for a newborn. That's why women can take off for pregnancy leave after they had the baby, and up to 12 weeks after they have, or a newly placed, adopted, or foster kid. So it doesn't have to be a baby they just had. It can also be an adopted or a foster child. You can also take off to care for a seriously ill child that you already have, a spouse or parent, or because of your own illness. It can be your illness. In other words, this law prohibits discrimination against employees who exercise these leave rights. So your job will be protected when you come back from this 12-month, up to 12 weeks per year leave. Immigration Reform and Control Act. It bars national origin and citizenship status discrimination. Applies to employees of 3 or more employees. So you can have a relatively small company, but you cannot discriminate because of a person's immigration status. The Privacy Act of 1974. This act states that no agency shall disclose any record which is contained in a system of records by any means of communication to any person or to another agency except pursuant to a written request by or with the prior consent of the individual to whom the record pertains. In other words, unless you decide to sign a waiver saying that you want your records disclosed, if there is a provision in there that you've signed and say that you want privacy or you do not want your records disclosed, then they cannot disclose that, because a lot of companies do sell personal records or personal information to other companies simply for profit. This is quite germane in the area of medical records, as a matter of fact. Additional disability provisions. The following sections of the Rehabilitation Acts ensure qualified individuals with disabilities are protected and are promoted per federal law. The pertinent sections in this are sections 501, sections 503, and section 504 of the Rehabilitation Act. Veteran Affairs. The Vietnam Era Veterans Readjustment Assistance Act requires affirmative action in the hiring and promoting of special disabled veterans, Vietnam era veterans, and veterans who served on active duty during a campaign for which a campaign badge has been authorized. It also applies to government contracts for at least $25,000 that relate to personal property and non-personal services, including construction. There's also the Uniformed Services Employment and Re-Employment Act. Now, moving on to the modern civil rights and anti-discrimination statutes. Probably everyone in my listening audience are familiar with Title VII, as it's been shortened to, but this is Title VII of the Civil Rights Act of 1964. Remember, there was the Civil Rights Act of 1964 and there was the Voting Rights Act of 1965. But probably the best known of all the Fair Employment Practices laws, Title VII prohibits discrimination in any aspect of employment, including help wanted ads, pre-employment testing, and on the basis of race, color, religion, sex, or national origin. In 1978, the Pregnancy Discrimination Act amended Title VII to prohibit bias on the basis of pregnancy. Employers with 15 or more workers, labor unions, and employment agencies are also covered by Title VII. Title IX bars sex discrimination, and it applies to educational institutions. So if you're seeking admission to a particular institution or professional school, higher education, even voc education, this will apply. The landmark case in this particular matter was Bakke a few years ago with reverse discrimination also, but it was a Title IX case also. Any institution of higher education such as vocational and professional schools. Workplace safety. The Occupational Safety and Health Act, also known or more commonly known as OSHA, employers have a general duty under OSHA to provide their employees with work in a workplace free from recognized serious hazards. That includes asbestos and any other known hazards that may be possessed in a particular building. OSHA is enforced through workplace inspection and investigation. We alluded to in another module that you must have these posters posted as to in your particular workplace area to be in compliance with OSHA. They do popcorn visits, and they will come by and monitor your business, make sure that everything is in compliance, and to keep down accidents in the workplace. What about workers' compensation? A big area, and I'll run over these, but there are 4 main ones that come out in workers' compensation that come to mind rather. The Longshore and Harbor Workers' Compensation Act, LHWCA, the Energy Employees Occupational Illness Compensation Program Act, the Federal Employees Compensation Act, and Black Lung Benefits Act. Basically, workers' compensation is any accident or illness that is derived from work-related activity. In conclusion, the U.S. Department of Labor administers and enforces more than 180 federal laws. These mandate and regulate workplace activities for more than 10 million employers and 125 workers. 125 million workers. As usual with any of my modules, if you require additional resources, you may consult Black's Law Dictionary, Westlaw, LexisNexis, FindLaw, lawinfo.com. I have been Professor Darryl Jackson, Bachelor of Arts from Grambling University and Juris Doctorate from Southern University Law Center. It has been my pleasure to provide you with this lecture. Thank you.